Hello, my name is Alan, and today we will be doing more U.S. Supreme Court. Today we will be talking about two courts, the Rutledge Court and the Ellsworth Court. Last time we left off, we talked about John Jay finally resigning after over 5 years in the role of Chief Justice of the United States, the inaugural Chief Justice. In 1795, John Rutledge, who was part of the inaugural court but had resigned after just a little over a year, came back to the court. This time, he was nominated by George Washington to be Chief Justice. And it was a position he would hold for only 138 days. From August the 12th, 1795 to December the 28th, 1795. So he replaced John Jay and became the new Chief Justice. But he was only in office for that 138-day period because of how slow the wheels of government moved. And so he was technically Chief Justice, even though his nomination ended up being rejected. But let's go ahead and take a look at John Rutledge. Let's see. He was from Charleston, South Carolina, where he was born and where he died, and was an American legislator who, as a delegate to the Constitutional Convention of 1787, strongly supported the protection of slavery and the concept of a strong central government, a position then possible but paradoxical in later times when slavery's defenders sheltered behind the bastion of states' rights. And this is often something you'll see a lot of today. People who still try to defend the Civil War talk about, well, it wasn't just slavery, it was about states' rights. Yes, but states' rights, about that much. Because if you look, and I did a video on this, if you read the reasons for secession for most of these states, slavery was usually the number one or number two issue. I think there was like one or two states that mentioned states' rights as one of the top two issues. So by and far, we know that it was more about slavery. But anyway, after studying in England, Rutledge returned to Charleston to practice law. Reflecting views acceptable to both planters and merchants in his area, he was chosen as a delegate to the Stamp Act Congress in 1765 and to the Continental Congress 1774 to 77 and 1782-83. After chairing the committee that framed the South Carolina Constitution in 1776, he was elected president of the state's General Assembly, but he resigned in 1778 when the Constitution was amended to include provisions he considered too democratic. In 1779, he was elected South Carolina's governor. And after the state was invaded by the British in that year, he held the skeleton colonial government together until the end of the war. At the Constitutional Convention in 1787, Rutledge spoke for Southern planters by supporting slavery. He argued in favor of dividing society into classes as a basis for representation, and also postulated high property qualifications for holding office. As chairman of the Committee on Detail, he recommended the granting of indefinite powers of legislation to the national government for the purpose of promoting the general welfare. From 1789 to 1791, he served as an associate justice of the U.S. Supreme Court, which we talked about last episode. And for the next 4 years, as Chief Justice of the South Carolina Supreme Court. Then he was nominated Chief Justice of the United States in 1795, but failed to win Senate confirmation because of his outspoken opposition to the Jay Treaty of the previous year. His brother Edward Rutledge was a signer of the Declaration of Independence, fought against the British in South Carolina during the American Revolution, and served in the South Carolina legislature from 1782 to 1798, and as governor from 1798 to 1800. So, yeah. But that's a bit of history about John Rutledge. And so, even though he doesn't get confirmed by the Senate to be Chief Justice, because the wheels of government move so slowly, he is Chief Justice for a few months. Let's look at this again. So August through December. August, September, October, November, December. August, September, October, November, December. So yeah, 5 months he was Chief Justice. 138 days. But while he was Chief Justice, we had no new members of the court. So he replaces Jay. He is in control when Paterson comes in, but John Jay was already Chief Justice when Paterson became a Associate Justice. But anyway, John Rutledge for a short 138 days. Let's take a look at the cases that were considered major during the Rutledge court. The court itself still took place at the old City Hall in Philadelphia, Pennsylvania. And honestly, they only have two decisions or two cases listed here that were considered important cases under the Rutledge Court. The first being the United States versus Peters. And that one says the United States Supreme Court. It was a case determining that the federal district court has no jurisdiction over a foreign privateer where the intended captured ship was not within the jurisdiction of the court. And the Supreme Court may prohibit the district court from proceeding in such a matter. In the decision, the court held the district court has no jurisdiction of a liable for damages against a privateer commissioned by a foreign belligerent power for the capture of an American vessel as prize, the captured vessel not being within the jurisdiction. The Supreme Court will grant a writ of prohibition to a district judge when he is proceeding in a cause of which the district court has no jurisdiction. But yeah, this case was in 1795. Do we have an exact date for it? It just says 1795, which that's all Rutledge served. So, but yeah, essentially, the federal district court has no authority over a foreign privateer when the captured ship is not within its jurisdiction. So, again, this is basically saying a federal district court cannot decide matters of international issues. Um, so, yeah. And the other case under the Rutledge Court is Talbot versus Jansen, also in 1795, that had to do with admiralty and citizenship. Let's take a look at it. Talbot versus Jansen was a case in which the Supreme Court of the United States held that the jurisdiction of the court extended to the seas and that a citizen of the United States could also hold the citizenship of another polity, in the case of Talbot being a citizen of France. This holding means that multiple citizenship may be held by Americans. So, being American doesn't mean you're just American. Is kind of the big one, but it also has to do with extending jurisdiction by the courts over a portion of the seas, which is now recognized by most countries. There's a portion of the sea that's recognized for along the coastlines of a country. But that was mainly it for the Rutledge Court. Now, Rutledge resigned at the end of 1795 on December the 28th. He was replaced by Oliver Ellsworth of Connecticut, who would become the new Chief Justice for 4 years and 282 days from March the 8th of 1796 to December the 15th of 1800. So yeah, Rutledge is replaced by Ellsworth because where Rutledge resigned, we have Oliver Ellsworth. Now let's take a look at Ellsworth. He was born in 1745 in Windsor, Connecticut, and died 1807 in Windsor, Connecticut, and was American statesman and jurist, chief author of the 1789 Act establishing the U.S. federal court system. He was the third Chief Justice of the United States. So not only is he a Chief Justice, he wrote that act in 1789, because if you remember the first episode, we talked about this. That not only was it Section 3 of the Constitution, but also this Act of 1789 that helped set up the Supreme Court and the justices. And Oliver Ellsworth was the chief author of that act. Ellsworth attended Yale and the College of New Jersey, now Princeton, graduating from the latter in 1766. After pursuing theological and legal studies, he was admitted to the bar in Hartford, which he represented in the Connecticut General Assembly. He was subsequently the state's attorney for Hartford County in 1777. A member of the Continental Congress, 1777 to 1783, and a member of the Governor's Council of Connecticut, 1780 to 1785, and a judge on the state's Superior Court from 1785 to 1789. In 1787, Ellsworth, together with Roger Sherman and William Samuel Johnson, represented Connecticut at the Constitutional Convention in Philadelphia, serving as a member of the important Committee on Detail. At the convention, he proposed with Sherman the decisive Connecticut Compromise, by which the federal legislature was made to consist of two houses, the upper having equal representation from each state, and the lower being chosen on the basis of population, which we know as the Senate and the House of Representatives. The Senate is equal representation, 2 representatives for every state, and the House of Representatives being the number of representatives being decided by the population. This bargain is a keystone of the U.S. federal system. To secure Southern support for the Constitution, Ellsworth supported free international trade in slaves. He also vigorously defended the Constitution at the Connecticut Ratifying Convention. His letters to a landholder, printed in the Connecticut Courant and the American Mercury, had a broad influence during the ratification debates, much as the Federalist Papers did in New York State. In 1789, Ellsworth became one of Connecticut's first U.S. senators and the acknowledged Federalist leader in the U.S. Senate. He reported the first Senate rules and suggested a plan for printing the journals, shaped the conference report on the Bill of Rights, framed the measure of admission for North Carolina, helped devise the government of the territory south of the Ohio River, and drafted the first bill regulating the consular service. He was chairman of the committee to establish the federal court system and the chief author of the Federal Judiciary Act of 1789, the principal basis ever since of the U.S. court structure. In 1796, President George Washington appointed him Chief Justice of the Supreme Court of the United States after John Rutledge, who failed to receive Senate confirmation, and William Cushing, the senior Associate Justice, had declined. Ellsworth's service on the High Court was cut short in 1800 by ill health. In the 1790s, Supreme Court justices also served in the circuit courts, and some of Ellsworth's most important decisions were given on circuit. His most controversial opinion was the United States versus Isaac Williams, which applied in the United States the common law rule that a citizen may not expatriate himself without the consent of his government. In 1799, he accepted President John Adams' request to join William Vans Murray and William R. Davy as commissioners to France to negotiate a new treaty. In October 1800, Ellsworth persuaded Napoleon to accept a compromise convention that provided for freedom of commerce between the two nations, and in effect concluded the undeclared war between the United States and France. From France, he sent his resignation as Chief Justice. Until his death in 1807, he lived in Windsor, Connecticut, and through his career included few acts of genius and little public acclaim. Ellsworth's political skill, balanced judgment, and clarity of purpose entitle him to recognition as a founder of the highest stature. Ellsworth lacked the intellectual brilliance of some of his contemporaries, but in the arena of practical politics, none of the founders was superior to, or perhaps even equaled, Ellsworth in the pragmatic art of effectively wielding power in legislative assemblies. In particular, Ellsworth had an extraordinary ability to fashion workable compromises. He had a clear, sophisticated, and detailed political philosophy and psychology, but he was not a member of the secular Enlightenment. Instead, he was a strict Calvinist who claimed that as a young man, he had personally experienced his election by God for salvation. His entire personal and public life was ordered by rigorous Calvinism founded upon a belief in absolute predestination. He firmly believed that everything he did was part of God's plan for mankind. In the political realm, he enthusiastically embraced compromise as long as he was convinced of the overall righteousness of a particular project. Like all Connecticut Calvinists, Ellsworth firmly opposed slavery on religious grounds. because he had an abiding faith that, as part of God's plan, slavery inevitably would wither away, he had no qualms about firmly supporting the Southern states' rights to import slaves in order to gain Southern support for the Constitution at the Constitutional Convention. So, yeah, through his religion, he did not support slavery, but his belief in predestination made him basically believe that slavery would inevitably disappear. So he's like, I've got no problem in supporting the southern states' right to import slaves because that'll help us gain support we need. By the time of his mission to France in 1800, he had reluctantly concluded that the federal government was unworkable. He cherished order, but the emergence of Thomas Jefferson's Republican Party and rifts within Ellsworth's Federalist Party presaged disorder and even chaos. Ellsworth resigned from the national government and returned to Connecticut, where he was an active participant in state politics for the rest of his life. So yeah, that's from Britannica.com. It's its short biography on Oliver Ellsworth, who, as we already mentioned, replaced Rutledge as Chief Justice. And the Ellsworth Court was also in the Old City Hall in Philadelphia, Pennsylvania. Now, under Ellsworth, before Ellsworth even became Chief Justice, we did get a new Associate Justice in between Rutledge and Ellsworth. Because John Blair resigned October the 25th of 1795. He was replaced by Samuel Chase of Maryland, who was a member of the Supreme Court for 15 years and 135 days. From February the 4th of 1796 to June the 19th of 1811. And these two people were the last justices picked by George Washington for the Supreme Court. So you had Rutledge come back to be Chief Justice, though he was never confirmed. When Rutledge left, before Rutledge left, Blair resigned, and after Rutledge's resignation, Chase came in to replace Blair, and then finally, a month later, Ellsworth was chosen to replace Rutledge. Then we had the presidency of John Adams. And he had 3 justices that he was able to put on the Supreme Court. And 2 of them we will talk about a bit in depth today. The first being Bushrod Washington, who replaced Wilson, James Wilson, who had died as an associate justice. Bushrod Washington was from Virginia, and he was a member of the Supreme Court for 31 years and 17 days. So, yeah, from November the 9th, 1798 to November the 26th, 1829. And let's take a look at Bushrod here. Well, let's take a look at Samuel Chase first. We hadn't done that yet. Samuel Chase, who replaced Blair, was born 1741 in Princess Anne, Maryland, and died 1811 in Washington, D.C., was an Associate Justice of the U.S. Supreme Court, whose acquittal in an impeachment trial in 1805, inspired by Thomas Jefferson for political reasons, strengthened the independence of the judiciary. Chase served as a member of the Maryland Assembly from 1764 to 1784, and in the Continental Congress from 1774 to 1778, and also from 1784 to 1785. As a member of the latter, he signed the Declaration of Independence. He went on to serve as a judge of the Baltimore Criminal Court and then as Chief Judge of the Maryland General Court from 1791 to 1796, when President George Washington appointed him to the U.S. Supreme Court. In Ware versus Hilton, 1796, an important early test of nationalism, he upheld the primacy of U.S. treaties over state statutes. In Calder versus Bull, 1798, he asserted that legislative power over liberty and property is limited by certain vital principles in our free republican governments. Later courts read these principles into the due process of law clauses of the 5th and 14th Amendment to the Constitution. During the struggle between the Federalist and Jeffersonian Republican parties, Chase, a Federalist, conducted his circuit court in a partisan manner. The House of Representatives, encouraged by Jefferson, charged Chase with improper actions in treason and sedition trials and a political address to a grand jury. In March of 1805, the Senate, acting as trial court, found him not guilty. His acquittal, by establishing the principle that federal judges could be removed only for indictable criminal acts, clarified the constitutional provision, Article 3, Section 1 of the Constitution, that judges shall hold office during good behavior. Some scholars believe that if Chase had been found guilty, the Jefferson administration would have proceeded against other Federalist judges, particularly Chief Justice John Marshall, a leading opponent of Jefferson. And that's all we really have on Samuel Chase. Let me move my feet around here a bit. And then, as I mentioned, um, we had Bushrod Washington replace Wilson, who died as a associate justice. And Bushrod Washington was the first justice nominated by John Adams. Let's take a look at Bushrod Washington. He was born in 1762 in Westmoreland County, Virginia, and died in 1829 in Philadelphia, Pennsylvania. He was an Associate Justice of the U.S. Supreme Court from 1798 to 1829. A nephew of George Washington, he graduated in 1778 from the College of William and Mary in Williamsburg, Virginia, where he was one of the original members of the Phi Beta Kappa Society. He served in the Continental Army until the end of the American Revolution. He then studied law at Philadelphia under James Wilson, practiced law in Alexandria, Virginia, and moved to Richmond in 1790. He served in the Virginia House of Delegates in 1787 and sat in the Virginia State Convention that ratified the Constitution in 1788. In 1798, Washington was appointed to the Supreme Court by President John Adams. In 1802, John Marshall became Chief Justice, and Washington thereafter generally agreed with the important opinions Marshall rendered as Chief Justice. After the deaths of George and Martha Washington, Bushrod inherited their home, Mount Vernon, as part of their estate. He served as George Washington's literary executor and supervised John Marshall's Life of Washington. So yeah, that's all they have on Bushrod Washington. The last person who became a justice under this in this period, being nominated by John Adams, was Alfred Moore of North Carolina. He replaced James Iredell, who had died as an associate justice. Alfred Moore served for 3 years and 280 days from April the 21st, 1800 to January the 26th, 1804. So, there we have a look at the justices we wanted to talk about in this episode. Let's look at the Ellsworth Court. Well, let's take a look at Alfred Moore first, since he's the last person we needed to talk about. Alfred Moore, born 1755 in New Hanover County, North Carolina, and died 1810 in Bladen County, North Carolina, was an Associate Justice for the U.S. Supreme Court. Moore's father, Maurice Moore, 1735 to 1777, and Uncle James Moore, 1737 to 1777, were both prominent in the early American Revolutionary cause. Moore himself was admitted to the bar in 1775, but spent the next 2 years as a military officer in the Revolution. He took part in the defense of Charlestown, later Charleston, South Carolina, in 1776, and upon his return to North Carolina in 1777, he resumed management of his family's plantation, but headed a local militia that harried the British. In 1782, he entered politics, gaining prominence as Attorney General of North Carolina, but resigning in 1791 after the legislature forced him to divide his duties with the newly created office of Solicitor General. He served a term in the state legislature and returned to private practice. His reputation continued to grow, and he was elected as a judge of the Superior Court in 1798. The following year, President John Adams appointed him to the U.S. Supreme Court to replace James Iredell. Moore's only opinion, Boz versus Tingey, 1800, in which the court held that a limited partial war existed with France, was welcomed by Federalists, but criticized by Republicans. Moore retired in 1804 because of ill health. So yeah, Alfred Moore. Now let's take a look at the Ellsworth Court. Okay. They have 4 major cases listed here. The first was from 1796, was Hilton versus the United States, which dealt with tax on carriages. A little more in depth, it says Hilton versus the U.S. is an early U.S. Supreme Court case in which the court held that a yearly tax on carriages did not violate the Article 1, Section 2, Clause 3, and Article 1, Section 9, Clause 4 requirements for the apportioning of direct taxes. The court concluded that the carriage tax was not a direct tax, which would require apportionment among the states. The court noted that a tax on land was an example of a direct tax that was contemplated by the Constitution. The case is also significant for being the first case by the Supreme Court to rely on judicial review, which was later formally established in the case Marbury versus Madison, to decide whether a statute of Congress was unconstitutional. The next case we're going to talk about was Hollingsworth versus Virginia, 1798. It dealt with the ratification of the 11th Amendment, which we talked about last episode, and presidential approval is unnecessary for a constitutional amendment. So let's take a look at that. It was a U.S. Supreme Court case that ruled early in America's history that the President of the United States has no formal role in the process of amending the U.S. Constitution, and that the 11th Amendment was binding on cases already pending prior to its ratification. So it was active retroactively. So yeah, the next case we're going to talk about is Calder versus Bull in 1798, which dealt with the ex post facto clause as it applies to criminal, not civil cases. Let's take a closer look at that. A United States Supreme Court case in which the court decided 4 important points of constitutional law. First, the ex post facto clause of the United States Constitution applies to criminal laws that have at least one of 4 effects. First, every law that makes an action before the passing of the law and which was innocent when done, criminal, and punishes such action. Second, every law that aggravates a crime, makes it greater than it was when committed. Third, every law that changes the punishment and inflicts a greater punishment than the law annexed to the crime when committed. And fourth, every law that alters the legal rules of evidence and receives less or different testimony than the law required at the time of the commission of the offense in order to convict the offender. The decision restates this categorization later as laws that create or aggregate the crime, or increase the punishment, or change the rules of evidence for the purpose of conviction. So yeah, basically any laws that don't set a standard and allow rules to be changed during a trial, or that affect what was done to make it a crime to get a conviction. Second, the Supreme Court lacked the authority to nullify state laws that violate the state's constitution. This court has no jurisdiction to determine that any law of any state legislature, contrary to the constitution of such state, is void. So, yeah, they can't nullify a state's laws that violate that state's constitution, even though the Supreme Court laws do supersede state laws. Third, the Supreme Court said that no man shall be compelled to do what the laws do not require, nor to refrain from acts which the laws permit. And fourth, the Supreme Court decided that this specific act of the Connecticut legislature and of other state and any other state legislative act is not a violation of the ex post facto clause if there is no fact done by bull and wife, plaintiffs in error, that is in any manner affected by the law or resolution of Connecticut. It does not concern or relate to any act done by them. And finally, let's look up ex post facto. An ex post facto law is a law that retroactively changes the legal consequences of actions that were committed or relationships that existed before the enactment of a law. So, basically, when somebody does something, you try to imprison them by saying, well, the law was meant to always say this, and thus you are guilty. That's kind of an ex post facto. And yeah. So it was talking about the ex post facto clause as it applies to criminal cases, not civil cases. And the final case we want to talk about from 1799 is New York versus Connecticut. This was a lawsuit heard by the Supreme Court of the United States between the state of New York and the state of Connecticut in 1799 that arose from a land dispute between private parties. The case was the first case in which the Supreme Court exercised its original jurisdiction under Article 3 of the U.S. Constitution to hear controversies between two states. So, yeah. And that is why that one had a bit of an importance. Now, as we mentioned before, Oliver Ellsworth would only be Chief Justice for 4 years and 282 days, and he would resign, getting replaced by one of the major figures in Supreme Court history, John Marshall. But that is something we will talk about in the next episode. So, as always, educate thyself, think, read, study, learn. Someone tries to tell you something you have trouble believing, ask them to cite their sources. I will have the sources for this video in the description below. But I'll see you all in the next video. Until then, later.